Good morning, everybody, or good day in particular to our friends from Asia. Thanks for joining our, I want to say, heads up seminar for standard contractual clauses, a little bit Schrems too. This is meant to be, as we said, a heads up, just 30 minutes, very quick to get you up to speed what's going on at the moment in Europe around standard contractual clauses. And a very special welcome and thank you for our friends from Japan, because today it's autumnal equinox day, so it's bank holidays. And I have to apologize that when we set up this meeting, we did not consider this, but I saw from the participants that we have quite a few from Japan. So a special thanks for joining us, although you have bank holidays. For those who don't know us, I quickly refer to Chris.
Hi, everyone. My name is Chris Jeffery. I'm a partner in the tech and data team in London, working very closely with German, Dutch, and French colleagues on data matters as the UK becomes something of an outlier on data transfers, as we'll see shortly. Pau.
Thank you very much, Chris. My name is Paul Voigt. I'm a partner in Taylor Wissing's Berlin office, also focusing on tech and data, as do Axel and Chris. And before we go into details relating to the new standard contractual clauses and what you need to do now, right away, I think it makes sense to zoom out a bit and see why we arrived where we are right now. Basically, from a European privacy perspective, if you send data to anyone, you have to fulfill all the requirements from the GDPR, regardless of whether you send those data to recipients within the EU or outside the EU. You will always have to be transparent about what you do. You will always have to be proportionate, and you will have to ensure that you have a legal basis for sharing personal data, meaning any data that could potentially identify an individual person to another party. However, when you send data within Europe, you can assume that everywhere we have a similar level of data protection laws in place, because in France, in Italy, in Germany, the GDPR applies all across the European Union. This is different when data flows to a country outside the European Union. In this case, you can no longer rely on the data being protected by the same standards as they apply within the European Union. So if you send personal data to the United States, GDPR per se does not apply, and you will have to ensure that there is a comparable level of data protection in the country of the data recipient. And GDPR foresees various possibilities in order to ensure that. One possibility can, for example, be so-called binding corporate rules. If you are a group of companies, this group of company can subject itself to similar data protection rules, so that the same rules apply in Japan, in China, as they would generally apply in the EU. However, the most relevant, the most widely used safeguard to allow for transfers from the European Union to countries outside the European Union are the so-called standard contractual clauses. Those clauses are standard agreements provided and drafted by the European Commission, and if you conclude them without any amendments, generally you can assume that the recipient provides the same level of data protection as we have it in the European Union. Those clauses have been in place since 2001, 2004, 2010, so for a quite long time, and they have not been drafted having GDPR in mind, which entered into force in 2018. Yeah, so all of those clauses have been subject to old law, and they did not really fit the GDPR requirements. So for a long time, the European Commission had considered amending those clauses and adapting them to GDPR, but that has not happened over the last couple of years. Only mid-2020, so about 1 year ago, when the European Court of Justice handed down a very important decision for cross-border data transfers, this was the trigger for the European Commission to come up with the newly and amended clauses. What did the European Court of Justice judge mid-2020? In its so-called Schrems II decision, the European Court of Justice said, well, dear data exporters in the European Union, you may rely on standard contractual clauses for sending data to countries outside the European Union, and you may rely on the data importer subjecting itself to similar requirements as we have in Europe. That is all fine. However, this is just a bilateral agreement. It will only bind the parties, but you will also have to assess whether there are specific situations in the country of the data recipient that may impede the data importer from actually complying with the clauses. For example, because you have access rights by authorities in the country where the data importer is established, and those authorities could request access to the data. And even if you have standard contractual clauses in place, the authorities will still have access rights relating to the data because the authorities are not bound by the bilateral agreement based on standard contractual clauses that has been concluded between the parties. So the European Court of Justice said, dear data exporters, before sending data to countries outside the European Union and before concluding the standard contractual clauses, you will always have to assess the level of data protection in the recipient country to make sure that the importer is actually capable of complying with the standard contractual clauses. So the European Court of Justice said you will always have to do a so-called transfer impact assessment to assess the impacts of the transfer before actually transferring the data abroad. This decision was a trigger for the European Commission to come up with the newly amended standard contractual clauses. And those new standard contractual clauses that exist now, they are much more detailed, they are much more adapted to GDPR, but one of the biggest changes is that they also have this European Court of Justice decision Schrems II in mind, meaning that the data importer will no longer only be required to comply with GDPR requirements, but there are specific requirements in the standard agreement that oblige the importer to deal with access requests by foreign authorities in a specific way. For example, to limit the data that is provided to these authorities if they request access, to be very transparent to the data exporter that they have to provide this kind of data, obligations to fight potential access requests before the courts as far as possible. In addition to that, there is also a clause, the clause 14 of the standard contractual clauses, about which Axel will speak in a second a bit more in detail, which obliges the parties by contract, not just by law, not just by GDPR, not just by the European Court of Justice decision, but by contract to do a transfer impact assessment to assess the level of data protection of the data importer in the data importer's country and to document and provide respective documentation to the authorities at their request. So the requirements of the European Court of Justice have specifically been included into those standard contractual clauses that must not be amended in order to be valid. Those standard contractual clauses already apply right now and they can already be used. However, from next week on, from 27th September on, only the new clauses may be used if you want to transfer personal data from the EU to countries outside the European Union. And by 26th December of 2022, all existing agreements have to be switched to the respective new clauses. So quite a lot of amendment work about which we will speak in a second. Those are just the requirements from the European Union, which used to comprise the UK in the past, but because the UK chose to go down a different route and also actually try to go down a different route when it comes to privacy matters now, this may no longer entirely be the case for the UK. Maybe Chris, you can say a few words about how the UK will deal with those transfers in future.
Yeah, thanks, Paul. It's an interesting time in the UK generally. But in terms of data protection, we're in a strange position in that we stand apart in many senses in terms of data protection, but we have the same rules. So in advance of Brexit, the UK essentially copy and pasted the GDPR into UK legislation. So UK companies face the same challenges around Schrems, around data transfer impact assessments and supplementary measures. We've inherited all of that. But, and this is the key practical takeaway, the new EU SCCs are not a valid transfer mechanism under UK data protection law. So where UK companies are transferring personal data, we still are using the 2010 C2Ps and the controller to processor clauses and the even earlier controller to controller standard contractual clauses where we need to. And that means that agreements that deal with both transfers of EU personal data and UK personal data are using both the new and the old set of standard contractual clauses. And for the time being, at least for the next few months, we don't see a realistic way around that. It makes for chunkier, even more complex data processing agreements, but it is achievable. In terms of EU to UK transfers, very quickly, I think most will know that the UK got its adequacy decision. So where EU companies are sharing personal data with the UK, that may need a DPA, it may need a data sharing agreement, but it won't need standard contractual clauses. That adequacy is for 4 years because there's a suspicion the Brits may diverge from GDPR, and that's probably well-founded. Equally, in the other direction, UK personal data can freely go to the European Union because the UK government has made a provisional finding that the EU is adequate from a UK data protection perspective. But as soon as UK data starts going outside to third countries, particularly the US, but also to countries in Asia, UK companies have exactly the same challenges. Now, looking forward, the ICO, our regulator in the UK, has issued a consultation with 3 important elements in. Probably the best news is that they are thinking of having a very short 2-page addendum that if it's finalized, and it's not yet part of UK law, but if it becomes part of UK law, you'll be allowed to use that addendum alongside the EU SCCs, and that together, they're a valid transfer mechanism for UK law purposes. So I think everyone's writing to the ICO, including us, saying that's a great idea. Let's do that. Let's make it easy. So the UK aligns around these new EU SCCs. We won't know for sure. I think it'll be early next year before we see what's happened. The consultation ends in early October. And then even when the ICO has decided 40 days of parliamentary debate will need to happen. So we don't know for sure. The other elements we don't need to spend much time on. There's a UK specific international data transfer agreement, which is very different from the EU SCCs. In some ways, it's more risk-based and pragmatic, but just to have a separate agreement for the UK when so many companies are dealing with EU transfers as well, I don't expect that to be used in a significant number of cases. And then there's a tool for assessing your transfer, which again, if you're only looking at UK transfers, may prove quite helpful because it really looks at the practical risk to the data subjects, I think in a more focused way than the EDPB recommendations on EU transfers. So if you're only dealing with the UK, and not many of our clients are, that may prove a useful tool. But for now, I think we're really just hoping that addendum comes in so we can make UK and EU transfers, wrap them in pretty much the same bubble of the new EU SCCs, perhaps sometime early next year, and go forward accordingly. Very last quick point, consultation from the UK government. Obviously, Brexit was partly about the UK being able to move away from EU regulation, which some in the UK perceive as over-engineered. There's a consultation for the government to do just that on the UK data protection side, but it's to be more pragmatic, more business-focused, and really look at practical risk. Some may say we're there already effectively the way our regulator operates. That consultation is out there. Where it goes, what it means in terms of any changes to UK law is completely unclear. And there's an awful lot of politics involved in there. So nothing I think that businesses can sensibly plan on. But of course, we'll keep clients and contacts updated.
Okay. Thank you, Chris. Thank you, Paul. Let's jump in what's happening on the ground. What's happening with the authorities in particular? how they look on standard contractual clauses. And I have to say up front, in particular, the German data protection authorities, we have 16 because we have 16 German Bundesländer. They take this very serious, and they have a less pragmatic approach compared to the ICO in the UK. And when you ask yourself, what is the standpoint from the authorities to the standard contractual clauses, then you can really limit that to clause 14, which means Schrems 2. What we see is that the authorities don't really look at the standard contractual clauses as such, as an instrument. They just say, okay, that's coming from the Commission, fine. That's our new set of law for data transfers. They still take care about Schrems 2, and Schrems 2, as Paul mentioned, is embedded in the clauses 14 and 15. In particular, in this first initial phase, clause 14 is relevant. And I want to say the magic footnote number 12, which is really helpful for those who export data. The authorities have quite a different standpoint compared to the companies and the data exporters and those who want to do business. We see even among the 16 German authorities, there's not a common approach. We have the more southern data protection authorities who are a little bit more pragmatic. We have those in the north, Berlin, Hamburg, Brandenburg, who are more dogmatic. And they think, well, Schrems 2, which is clause 14, more or less says data transfers in particular countries like United States, like China, Russia, those who have, let's say, local surveillance laws who might undermine the high level of data protection with respect to the EU data imported, there shouldn't be any transfer, please switch off. So they have this idea that you can very quickly move to a EU provider. Whereas, of course, our clients, they have the opposite approach. They say, well, I want to continue my business. And what I'm doing is I beef up my data transfers with the new standard contractual clauses, and I make everything happen that in particular Schrems 2, clause 14, our TIA transfer impact assessment is running and working. What we see with the authorities, there are, let's say, three different approaches towards our clients, practically spoken. We have some authorities who want to set up a dialogue with companies. We call it informal approach. So they say, well, we would like to have an exchange about how you're dealing with your data transfers. And it's a little bit of a, I don't want to say shady, but a kind of interesting procedure. On the one hand, companies are obliged by the GDPR to work together with authorities. But then again, it's unclear. Is this really a formal procedure? Is this just like you say something and you exchange? Does this, what we give to the authorities, can be used against us at a later stage? It's a little bit vague, and the authorities, I must say, are still learning in this situation. That's the informal approach. And our recommendation is keep up with your authorities. Don't say, I don't speak with you. Don't say a single word. Please sue me. That doesn't really work. The second one is a reactive approach. This is what happens if data subjects are complaining. And that's very easy. We have one case, one employee very close to work councils said, oh, well, we use Microsoft Office, and I think this is a data transfer to the US. I don't like this. I rather go to my authority and tell them to stop this. And then the authority has to start and initiates a proceeding to investigate that data transfer. So that's painful, and there is room for escalation. It's very easy for employees, for consumers to whistleblow and trigger this. And the third approach, I want to say, is the formal approach, which is already starting now. There are, I would say, half of the German authorities, they started with the kind of a questionnaire proceeding. They send it out, 5 different types of questionnaires concerning particular data transfers to approximately 50 companies in each Bundesland. And those who got that, they're really like, they're very unlucky, because they have to work with these very, very granular questionnaires and to give all details, which you are supposed to give according to clause 14 of the SCCs. So they take it, it's not like an easy thing. It's a kind of a project to answer these questionnaires in a satisfactory way. Last bit here, what does it mean for you? Is this a formal proceeding? Yes. These letters, at least those we saw and we have on our desk, came in together with an explanation that this is a formal proceeding. You had been introduced about your rights and the possibilities, what you can do against that. And if you kind of don't follow the request of the authorities, it's very likely that after that first questionnaire, they come back with an order from the authority telling you to either give more information or stop the transfer or answer to particular questions within a certain deadline. We're not there yet, but this will be the next escalation. And the last escalation ahead, but we don't see this now, would be, of course, penalties. For the time being, that's a good news. I haven't heard about any penalties which are out. And it's much more likely, because there's so much uncertainty also for the authorities, that they don't jump in with a high penalty if you're not in compliant with standard contractual clauses and Schrems 2. It's more likely that if you don't if they're dissatisfied with what you're doing and you have this chance in writing back and forth, and we have meetings, actually a webinar, online meetings with authorities discussing progress. And only if they're dissatisfied with your progress, the risk is that they come in with a formal order telling you, as I said earlier, an administrative order telling you to do something. And if this still doesn't really work, then the next step would be on top. They would shift the procedure into a kind of penalty procedure. But I don't see this year. I hardly think this will happen next year. My guess here is you will start to see penalties when the second deadline is over, which is the 27th of December, 2022. Paul mentioned that deadline because this is the deadline when you need to have to replace all standard contractual clauses, the old one, with a new one. And this also contains that if you have to replace, let's say physically, all these contracts, this also includes clause 14, which is Schrems 2. That means by that deadline, naturally, you need to be, you have to have your ducks in the row with respect to Schrems 2 as well. So if I would be an authority, I would rather take this second deadline, 27th of December 2022, also as a deadline that from there on, I may go stricter against companies, including penalties. So this is the landscape with the authorities. And now, practically speaking, what can we do? What is to do? And I must say, the most important thing is start. If you haven't started yet, you really need to start. In particular, that second deadline, it sounds like, oh, I have a long time going forward, but it's not. It's a huge effort to replace all these SCCs. And I must recommend start now. Chris, Paul, what do you think? What do we have to do now?
I mean, I think, jumping in, I think you're absolutely right. If you haven't started already, you really do need to start now. And of course, the first step is to understand where all your data goes in the world. And if you've got that from your GDPR audit or it needs a quick refresh, then great. But that's got to be the starting point. We've had a few clients, and I understand how in-house teams are usually firefighting and reacting to issues that come in. but some of them have been surprised by, say, if they're in the B2B space, by a customer saying, okay, well, great, we agree the price and the service and all the product, whatever it is. Where's your new SCCs, given that they're coming in very shortly? And then there's a massive scramble, and it doesn't look good to the customer that you're not ready. So you need those outward facing pieces ready now if you're B2B, but then you also need to be really kicking off with the internal preparation as well. From a UK perspective, the ICO is not active. It's not going looking for trouble. I think it's sitting back, but next year, as Axel says, I think the ICO in its usual pragmatic way in the UK will be expecting companies to be getting on with this.
Maybe Paul, for the TIA, which I think is the core work product.
Exactly. So like the point that Chris raised is quite important. Actually, know your transfers, data mapping, that sounds easy, but we experience in practice very often, despite the ongoing GDPR projects, the information is not readily available. It is also often difficult to actually find out the contractual documents that you need to get all that together. That's actually a big part of the process. And obviously, you need to come up with a concept for transfer impact assessments. The transfer impact assessments are the major part of those new standard contractual clauses. So you can't just conclude them, check the box, and put them into your shelf as you could have done in the past, but you really upfront every time you will need to conduct such a transfer impact assessment. So if you're an importer outside the EU, you will have to come up with some information for the exporters, explaining them what you will do with the data, why there are no authority access possibilities in your country, or if there are, what you can do against them. And if you're an exporter that wants to send data to a country outside the EU, you should come up with a streamlined process with respect to TIAs. So with specific questionnaires, asking specific questions, and think about how you will actually evaluate the answers that come in, so that you don't have to look at each answer independently and guess what will be the right answer, but rather have a streamlined approach, knowing, look, if those are the answers to my questionnaire, we see a high risk, and if the answers are differently, we see a low risk, and we can keep on transferring the data. All of this needs to be very well documented. This is, I think, the key fact. What we also hear from the authorities is they will very often not be able to really challenge in detail the TIAs that you have conducted, because they don't know the law of Japan, of China, of India, etc. in detail neither. So they will have to rely on your work to some extent, but you will have to ensure that actually all the data importers are fully handled, so that you don't miss some of them, and that whatever you come up with is reasonable and sounds like a reasonable approach. So you really must have assessed what needs to be done, have done something, and documented that in a reasonable way to have some kind of defensible position, or even more than a defensible position, a lawful position, in order to keep on transferring the personal data.
Yeah, it's heavy work. And there's one question complaining about availability of documents, practical questions, standard contractual clauses. Please go on our website, Taylor Wessing. We have a so-called SCC generator where you can build your SCCs free of charge. And this comes from a law firm. So take that advantage. Yeah, Franziska is just sharing it. So if you have more questions, by the way, please write to Chris, Paul, or myself. We're very happy to keep up the communication, and I'm sure there will be another heads up by the end of the year or beginning next year. So we will make it a kind of a series about what's going on with the SCCs, and we hope that this format, being quick, give you a heads up, just 30 minutes, is helpful for you. Paul, Chris, last words? Or
maybe just to summarize, don't underestimate the work that you need to be doing relating to the new standard contractual clauses. Just finding out how many data transfers you have is already quite a big burden, and end of 2022 may seem like a long time, but from our experience, it is not. So you really need to start preparing the respective work, getting decent teams in place, a decent organized structure in order to be able to cope with the new requirements.
Good. It leaves us to say goodbye. Time is over. It's 11 o'clock. We want to be punctual. So have a nice evening in Asia, a nice day here in Europe. Please keep in touch. Goodbye and see you soon. Bye-bye.
Bye-bye.
Thank you. Bye-bye.